Okay, we're live. I'm attorney Vince Davis, and this is The Secret: How to Fight CPS and Win. I'm joined by my two co-hosts, Miss G. Georgette Truen. Miss Truen, how are you this morning? This evening.
I'm doing good.
Good. And our second co-host, Cassandra, Miss Cassandra Woodard. Cassandra, how are you today?
I'm doing pretty good.
Good. Good. So, no guests tonight. I guess we have question and answer. To start us off, do either one of you have questions that you want me to answer?
What is the difference between a protective order and a dependency order?
A protective order is usually as a result of a restraining order, a request for a restraining order that has been filed. A protective order can be granted in a regular civil case or family law case, but also in a juvenile dependency case, in the CPS case. So I hope that answers the question.
Um, isn't it like a difference in interest in terminology? The protective order is an order which is held and issued after a dependency hearing has occurred.
No, although it can be done that way, but that's generally not how it's done.
I actually heard that from a state judge.
From California,
Yep,
Hmm. A CPS judge.
an appellate judge.
Hmm. Was that on a video or something?
It was a court proceeding against a social worker.
Oh, that was a federal case.
It was at three appellate judges.
Yeah, that was the federal case you were watching, a
Yeah.
federal court of appeal.
Okay. He also mentions the due process that a judge cannot, if an attorney leaves your case before the hearing and you've had chances to get a new attorney, for example, the judge gave you a chance to get a new attorney, but that attorney did not show up that day. The judge cannot, by law, continue the hearing without an attorney present. And the judge, by law, cannot tell you you cannot have an attorney. Um, that's a no-no, and that is that's in violation. Uh, I guess the code that the judge mentioned was 15 11 19. So a party has the right to be present. Um, basically, I heard Attorney Davis one time say that to people that call us that if the judge, you have to ask the judge, you request from the judge to get a continuance and see if the judge will grant you the continuance. However, judges do grant the continuance, but sometimes they get ugly about it, or most times they get ugly about it and they don't want to give you a continuance. But in the case where you got a continuance, got an attorney, and then the attorney leaves the case at the last minute, and then you get another attorney, and that attorney doesn't show up to the hearing, then by law, that judge, juvenile court judge, cannot proceed with the hearing without an attorney present. I'm just wanted everyone to know that.
What's the question?
I already asked you the question. You already answered.
Okay. That one of the things that you just said is the general rule. There are exceptions, and we don't have to get into them, but I have seen judges, and it's been upheld on appeal, proceed without you having an attorney. You have to know what the prior orders stated. So, for example, the last time I saw that, um, at the hearing before, the parent fired their court-appointed attorney and asked for a continuance. I think the judge continued it like 2 weeks or 30 days or something, and said, "This is all you have to get your attorney. And if you don't have your attorney, we're going to proceed with you not having an attorney." And the judge then rightfully proceeded when the parent showed up again without a private attorney. So it depends. You can't take things in a vacuum. You got to take them in the context of the case. And a lot of times you won't know what the context is unless you do some research. A lot of people ask me, yes, is this if then that? And that's not the way how the law operates. You got to take the things in context. There are very few bright lines in the law. If then this, then that. So keep that in mind if you are planning to somehow not show up with an attorney. What did the judge tell you at the prior hearing? Now, if the judge didn't tell you that, you have a good argument for asking for another continuance to get you an attorney or to get a new court appointed attorney. So it can be a little tricky. Miss Cassandra, did you have any questions for me?
No, not at the moment.
Okay. Miss G, any other questions? You see any questions being posted? Here's one from Kiona Crenshaw. Do you have to do services not on a court order at a placement review hearing? Okay, I think your terminology may be a little mixed up there. Do you have to do services not on a court order? Well, court services are usually ordered by the judge. And a placement review hearing in California, the closest thing that they have to a placement review hearing under the statute is 6-month reviews. So if you're trying to get a child back, one of the things you have to do is show that you've, participated successfully in the services that the judge previously ordered. I was talking to a guy maybe a week ago, and the judge at the disposition hearing ordered a lot of things for this guy to do, including anger management. And he told me straight out, I'm not going to do anger management. They lied on me, blah, 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 blah. And I asked him, I said, well, did you appeal the disposition court orders to appeal that, you don't have to do anger management? And he said, no, I'm just not going to do it. Can you get me my child back? And my answer to him was probably not. Judges make these orders for a reason. They may be wrong, but that's why God made courts of appeal. You should appeal it. But for you to just say that you're not going to do it and walk back into court 6 months later thinking that you're going to get the child, you're probably 1 out of a 1,000 chance. Have I ever seen it happen? Yeah, I have. But like 1 out of 1,000 cases. There's other extenuating circumstances that require you to take the child. John Joe says, if the non-offending parent has a sexual battery from years ago, can the parent still get the child back? John, the answer to that is absolutely yes. All right. They have to prove that sexual battery from years ago somehow affects your ability to parent the child today. And that usually comes up. The case was brought for other reasons. Usually, the mother may have had some issues, domestic violence, mental health, drug, substance abuse. And then when they don't want to give the child to the father, they say, 20 years ago, you had a sexual battery, charge against you. Therefore, you're not fit. Well, that argument is not legitimate. They actually have to prove it. Because a lot could have happened within the last 20 years. Okay, John says, I'm doing services currently, not on a court order. Okay, John, I'm not sure what you mean by that. If you're doing reunification services, they usually order it in California. I'm not sure if you're in California, if you're in another state. But if you are doing services, you can use that to, get your child back. Nicole says, Do you need to respond to a TPR summons that you've been served with? Well, in California, Nicole, they don't really have a summons, they have notice of a TPR, and you and your attorney have to show up on the hearing date to challenge the termination of your parental rights. So I would say that the answer to that is the yes if you were in California. Ariel says, Miss G and Cassandra held it down since you left us yesterday. Oh, okay. I thought you guys didn't have a show yesterday. I thought it was a rerun. Kayona says, if CPS hides completed services and order services not court ordered, can you be in no progress or no compliance? Theoretically, you can't, right? However, I have seen this happen. The judge tells you to do A, B, C, D. You do A, B, C, D, and then at the 6-month hearing, the social worker says, well, you've done A, B, C, D. We don't want to give you the child back because you need to do E and F. And I don't believe, in my humble opinion, unless there's compelling evidence, that that is justified for keeping your child away from you. There are a lot of less restrictive alternatives, like give you the child and make you do E and F, right? But if they wanted you to do E and F, they should have brought it to the court's attention before the 6-month review hearing and, ordered you to do it. Okay. Paulo Velasquez. Have you heard of John Dodd, appellate attorney? Yes, I have. He is a very well-known appellate attorney in Orange County. Been around for years, probably doing this longer than me. And I've been doing it 30-some years. John Doe says, yeah, he's in California. Okay, John Doe says, I had been doing all they've been asking for 3 months, haven't missed any programs for reunification without a court order. Okay, John, then, you should be right in line to get your child back. And if you don't, you got to have a trial. Here's the thing that I want to mention to people. If you go to the 6-month review hearing and you've done everything and the social worker says, well, no, we don't think we should give the child back because of this or that, you have to tell your attorney that you want to have a trial. You want to have the hearing to present your evidence to show that the child should be returned. As a matter of fact, at these 6-month review hearings, the social worker has to prove that the child shouldn't be returned to you. So if you've done everything, they can't say, well, you haven't completed your services. What they actually have to do is prove, one, that you need more services for another type of service, or number two, that you didn't get anything out of the service. And that's where your witnesses come forward. Like if you have a counselor or a substance abuse counselor, you bring them in and, they get on the stand and they say, hey, mom doesn't need any more services. She did well in her counseling and in her, parenting class and her substance abuse class, right? But those people won't be there if you and your attorney don't subpoena them for the contested 6-month review hearing. Okay, Paulo says, he says, and I think this is John Dodd says, in dependency cases, appeal time limits are more flexible. I generally, Paulo, agree with that. John Dodd is an expert in appeals in CPS cases. I have found that to be true myself over the years, but I do know that certain divisions of certain courts of appeals are a little bit more strict than others. So don't think that, what Orange County Court of Appeals in Division 5 is going to do the same thing as, Los Angeles County or the Los Angeles District, we call it the Second Appellate District, is going to do the same thing in Division 3. Generally, you got to follow the rules. So don't rely on flexibility, Paulo. You could be caught on the short end of the stick. Okay, Ms. Crenshaw says CPS workers recommended things not to court order is what we mean. Do you have to do them if they are not court ordered, if you finish the actual court ordered services? Kiana, Ms. Crenshaw, that's a very good question. And I've seen it go both ways with judges. Some judges will say, well, you should have done it. The social worker told you you should have done it and you didn't do it. And then some, judges say, no, that's not fair. I ordered ABC at the disposition hearing, and that's all he had to do. If you wanted to walk on something or file a 388 to change, to add to your case plan, the social worker should have done it. But here's the thing, when they're making the disposition court orders, sometimes you don't pay attention or don't hear or don't read on the minute order extra things that the judge has ordered. And here's one extra thing the judge could order. You do ABC plus anything else the social worker recommends. And you leave that thinking you only had to do ABC, and here it is, the social worker saying do D&E, and you never did it, and then you show up at the 6-month review hearing thinking you're going to get the child back, and the social worker says, well, the minute order says anything else I recommend. And then you're going to be caught on the short end of the stick. Ariel Hopkins, oh dang, I had it backwards. John Doe, the law offices of Vincent W. Davis and Ms. G and Cassandra are doing God's work. Well, thank you, John Doe. Appreciate that comment. Okay. We have Paulo again. Due process is the only reason an appeal should be considered. I'd have to disagree with you that on Paulo. There's a lot of different issues. Many years ago, something like 20, 25 years ago, I used to do a lot of dependency appeals. As a matter of fact, I was a court-appointed appellate attorney for the second district. And also, I think I was on a couple of other panels throughout the state. But there are many reasons to appeal. Due process being one, being a big one, but there are always many more issues in an appellate case than you might think. Here's a big one that's very rarely brought up, and that's IAC. And that's a bad word in the legal community. And that means that you had ineffective assistance of counsel. I see that a lot when people hire attorneys that aren't really familiar with juvenile dependency. Well, one of the ways to get, the orders and the findings the judge made against you is to file an appeal claiming ineffective assistance of counsel. Now, you have to do much more than just claim it. You got to have facts and evidence to support it. But if your attorney didn't do what was necessary, then you should. I won't tell you when this happened. It was in the last 2 weeks. I'm on a case in another county in California, and I represent one parent, and the other parent was represented by a court-appointed. The court-appointed attorney, no, and that parent eventually hired a new attorney, a new private attorney, and that attorney called me, and we started talking about the case, and I could tell just from talking to her that she wasn't a very experienced juvenile dependency CPS attorney. So, I talked to her, tried to tell her some issues in the case, blah, blah, blah. Some of them registered with her, some of them didn't. So I only know that because I've been doing it 30 plus years. But, you have to be cognizant of who you are hiring to assist you. Ms. G, did you want to say something? Okay. All right. Nicole says he's probably just working a case plan. Okay, here's John Doe. Is 19 drug tests clean enough to prove a parent is not on substances without a court order? I'd have to say yes, but you don't automatically get that finding because some of them will say, well, you knew where the drug tests were going to be taken. They weren't random. You prepared for them, blah, 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 blah. And what I tell people in that situation, you got your 19 drug tests, but also get a hair follicle test that goes back, 4 months, 5 months, 9 months to show the judge, well, you got these 19 clean tests and you got the hair follicle. So that, the more evidence that you can bring forward, the better it is. All right. Matt W. Will CPS allow a child to visit out of state grandparent while in custody? Yes, the CPS will, but it's up to the judge. We just had a case like this where the foster parent wanted to take the child to another country, and it was ordered by the court. And I told my client that there's an automatic stay in California if the judge orders that the child can leave the state. And I think it stayed for 7 or 10 days. And in this particular case, the problem was they were leaving next week. They just asked for the order, which was granted, and then the attorney asked for a stay. Well, the stay went past the time they were supposed to leave for their trip, so either had to cancel the trip or buy new tickets. And the stay is for you to file a writ, an appeal to the Court of Appeals to try to get them or prevent them from leaving the state. Okay. Ariel Hopkins. Well, what's on God's green earth are you supposed to do when you have done A, B, C, D, and E and completed all of those services and you're still not getting your children back? Well, Ariel, this is what I was just saying earlier. You have to have a trial. You have to have a contest. If you're in California and you've done everything and you come to the 6-month hearing, you have to tell the judge you want to set it for trial so that you can prove that the child should be returned to you. And as I just said earlier, sometimes you do A, B, C, D, and E, and the social worker says, "Oh, don't give her the kid back," because she didn't get anything out of it when you have to bring your counselors to court to testify, or she needs F and G. And then you're going to have to show the judge that, number one, probably you don't need F and G, and number two, it wasn't ordered at the disposition case plan, and it was never walked on or 388 filed by the social worker to change the case plan. Nicole says, I am in North Carolina. The paper actually says I have 30 days to file an answer. Okay, that was the summons. The questions about the summons and DPR. In North Carolina, they must do it, differently than they do in California. And if you have a summons and it says you have 30 days to answer, I suggest, Nicole, you talk to a local North Carolina attorney. I actually know a good attorney. He's in Greensboro. I don't know where you are. But if you're interested, I can give you his name and number off the air. Okay. Charlotte is apparently upset about something. It says, Veronica Martinez, what would happen if I, as a parent, get hold of talk to the foster mother, which one of my children are with? Will I get in trouble? Probably if you don't have the permission of the foster parent to talk to you. In California, foster parents' contact information is supposed to be confidential. It wasn't always like that, but the foster parents several years ago had a very strong political arm that got the state legislature in California to change the law. Eric Santos says, Queen Miss G. Ariel says, and no 388 to be filed because he keeps evading the question and for a bond study. So what the hell am I supposed to do? Not to mention clean hair follicle tests over a year. You're going to have to talk to another attorney, or you're going to have to ask the judge in what's called a Marsden hearing to, get a new court-appointed attorney, or, you're going to have to hire your own attorney. Okay, Ariel, I didn't understand this comment. Oh, I effing hate those mother fathers, to say the least. Understood. Veronica. Miss G, have you ever talked to Veronica before? You're on mute, so I couldn't hear you.
I said, yes, I think so.
Okay. My children were taken away from my ex-boyfriend. They didn't acknowledge me or call me or got a hold of me for nothing until now recently. What can I do to get my children back from CPS? If you're in California, I'd go to court, get a court-appointed attorney, or hire an attorney to get your children back if you were never noticed. Okay, Ms. Crenshaw says, what if the CPS social worker and the AAG helped an abuser get an order of protection off by showing up at the hearing via Zoom saying they support him? I'm I'm not sure. As Ms. G has mentioned, that happens a lot. Abusers are supported by CPS in order to get custody of the children. I just talked to someone today where they told me that story, and the first thing I thought of was Miss G saying this. And since she said it, I think I'm starting to notice it more. It was one of those things I didn't notice, having not been a victim of domestic violence or of an abusive relationship. And I'm looking at it thinking, huh, there is something to that, to what she's saying. I just wasn't aware of it. It was like, so many years ago, um, something happened in my personal life, and I just wasn't aware that there were so many people out there that these things happen to. And I guess you have to be experienced or a victim of that scenario to really start looking at it. And it's weird. It's in this particular case, it was weird why the social worker would support, the alleged abuser against, in this particular case, the victim and the mother. I don't know if it's personalities. I don't know if it's bribery. I don't know what it is, but it's really a weird situation.
It's actually both um, bribery and personality, and only a demon would want the children to be tortured or abused. And
Mhm.
I mean, there's not human, there's it, a human, a normal human being would not want that. But again, they see the abuser as the victim and the victim as the abuser. And oftentimes they blame the mom for making a police report to protect herself and the children. But if the mother um, called the police, how did she feel to protect? It's common sense, but they always, all the police reports, domestic violence or abuse, always go under the mother's name. So,
Yeah, the case is always under the mother's name, at
mhm,
least in California.
mhm.
Um, have you talked to people, Miss Woodard, that have communicated that to you about the abusers being helped in the system and the victims not being helped?
Yeah, I have a couple of times actually. I've experienced it myself also.
Um, did you ever take any like group counseling or group parenting classes where you met people where they had this similar story?
No, I can't say that because I wasn't in a group kind of setting for my
Mhm.
parenting classes. But I've had friends and people around me who've had a problem like this before. Like, and it seems like everybody favors the abuser or favors it's not just like the courts, it's like a lot of people actually do that. And I think it's mostly because they victim blame. A lot of people victim blame. And it's just our culture, I feel like. It's people just take it like that.
Mhm.
I don't, it's, yeah, you're right, Cassandra. I agree with you. It's the culture. And the sad part is that there's a father group out there that actually they have like their phone numbers on like freeways and stuff like that, and like walls where they help fathers manipulate the court to get custody of their children so they can avoid child support. And the reason I know this for a fact is because there was a couple of people, guys actually, men, that pretended they had a case and they called that number and they taped the whole conversation. And they actually, people from the court system who are previous district attorneys or whatever, that have connection with the courts, that tell them how to go around it where the father gets full custody of the child and how to play the victim and all that. I asked that individual, or the two individuals, their cousins, if they want to join us on the show one day, but they don't want to do it. But they had me, you know, they had me look at the video. So there are groups out there, that father groups, that actually enable the wrong for the fathers to win custody, even when the father is the abuser.
Lloyd Christmas says, if losing your appeal after a jurisdictional dispositional trial can be used against you when suing CPS, and it can the opposite also be true? I.e., you win your appeal and use that against CPS in a lawsuit? The answer is yes. Now, it depends on the facts of the case, how much or how strong that's going to be, but every case is different. Paolo says, my social worker referred me to an Indonesian gambling site and a mechanic. I'm not sure what you mean by that, Paolo. Amy says, hey, Miss G, are you doing better? I hope you don't have a hip fracture from the split yesterday. Call me if you can. Nicole says, yes, I'm interested. Okay, here's Paolo again. My situation is pretty weird. Sister is caretaker of my kids. I work for her. My father and sister conspire against me because the social worker makes me look bad. Okay, I mean, Paolo, welcome to the CPS world. Everybody has their own agenda, my friend. Sometimes it's money, sometimes it's power, sometimes it's control. If your sister has your children and you work for your sister, that's a little bit too much control over you. You might want to talk to your lawyer. Connie from Marietta says, my social worker won't increase our visitation. What can we do? Judge ordered it. She's also lying, saying that we're not participating, which we are. She also intercepted the call when we tried calling the supervisor. What would you suggest, Miss G?
If the social worker refuses to increase your visitation, that's because, in my opinion, they're working towards adoption. And oftentimes they do that. So, depending on the age of the child, they slowly start saying that, you can't see the child as often. I honestly believe that's the time, actually, before even then. But if you're stuck in it right now, you need an attorney immediately. Do not depend on your court appointed attorney. In my opinion, court appointed attorneys are scumbags. I seriously despise all of them because they're useless. They're so useless because they get paid on your case whether they work on your case or not. Remember that. And in my humble opinion, you cannot trust um, people that work for the county. I really do not trust them, or the state, or the
Miss
government.
Miss Cassandra, I see you nodding your head. What do you think?
I think the same thing. I definitely don't trust the county, especially my county. Don't trust
Any
anybody
county,
in
any state, they want money. All they care about is placing your child. Then they tell the children your mom and dad didn't want to come and see you, and then they traumatize the children even further. It's they create trauma in the whole family, and
the
they separate and lie and withhold evidence, and oh my god, I just, I can't trust people like that. Can't. Mm-mm.
Here's John asking, can he be on the show?
I think John was on the show before.
Really?
I think so, John, if I'm not mistaken, if you're the same John that I know. But let me know. If not, you have my number, John.
Also, John, I posted an email. You can get in touch with our moderator and producer, Grace, at vincentwdavis.com. John says, apparently John agrees with you, Miss G.
Yep. Yeah, they're useless. Actually, nice to say useless. I was going to say something else.
Okay, Paulo says, my child was taken by the ambulance when they received code blue kangaroo. I'm not sure what that means, Paulo. Miss Woodard, do you know what he's referring to?
Kangaroo. The only thing I can think about is kangaroo court. Um, Kangaroo court, kangaroo police department. Either or, they're both kangaroos.
Okay, Brian says, people often don't realize they can call the ombudsman. In Texas, it's called the Office of Consumer Relations.
Actually, people do know that, Brian. Unfortunately, they don't do shit. So yeah, we do know that.
Yeah,
But
I've called them twice.
yeah,
Twice.
everybody. So if you think you're gonna get results from them, you're mistaken. But you can learn on your own.
What would you suggest, Miss G?
I suggest to file a complaint with um oh my goodness, Department of Health. What did you say it was before? Department of DHHS, maybe, if I'm not mistaken.
Department of Health and Human Services
Yes,
in
thank
Washington,
you.
D.C.,
Yes. Yeah.
and also the Department of Justice, Civil Rights Division in your geographic location.
Yep.
Okay, Lauren asks the question, can they order a hair follicle before chins during the assessment in Indiana? I'm in Decatur County, Indiana. Lauren, I can't answer that question. I'm only licensed to practice in California, and I'm not sure what chins is. In California, there's authority that says a judge cannot order a hair follicle test, drug test in a CPS case. However, many do, and the law is if you don't object to it, then it's valid. Okay? John Doe, can you give me a call? It must be the John Doe you know, Miss G.
Yes, John, I'll give you a call, Eddie.
No, he said no, he wasn't on
Oh,
further comment.
Oh, yeah, different John Doe. Well, John,
just email me, John, at gat@vincentwdavis.com. And make sure you include your phone number, your cell number, so I can text you.
okay, here's a question from Harley. Is a caregiver allowed to lock the children's room on the outside during the day so the child isn't allowed access to his room for his clothing, books, his general comfort spot? My son hates it. Well, Harley, I would say that probably crosses the line of reasonable parenting or caregiving. Um, every once in a while you hear some crazy things foster parents do. And what I would do is I would bring it to my lawyer's attention and ask the lawyer to bring it to the minor's attorney's attention and possibly the judge's attention. Your child may need to be moved. Let me tell you this, Hartley. There must be a reason why you haven't had the child placed with a relative, a friendly relative, or a friendly friend. That person can live anywhere in the world if you have a case in California, and they don't have to live in the county or in California, despite what a social worker may tell you. Okay, John says, my public defender didn't even come out to my court hearing to speak to me when they called me in. She was like, oh, sorry, I didn't know you were here on the first hearing. What do you have to say about that, Miss G? You heard that?
Um,
Have you heard that before?
yeah, I heard that a lot, John, a lot. And some of them don't even, they literally meet their attorneys inside the courtroom.
I have a piece of advice for all of you that are listening. If you're a parent with a court-appointed attorney, if that ever happens to you, you should tell the judge, "Look, judge, I'm not ready to do this case. I haven't even talked to my attorney." in my opinion, most judges will say, okay, go outside and talk to your attorney.
And I hope to God they tell you no, so you can appeal it and take their asses out. Because actually, you can actually request for another judge. I was told you can recuse a judge in a juvenile court and request for another judge.
Brian Bridewell says, I was thinking of the person trying to get hold of the supervisor. Ombudsman notifies the supervisor. You can also go further up the chain of command. The ombudsman can give you that information. I haven't had very much success with ombudsmans. That's just me.
There,
What? What were we going to say, Miss G?
they have you guys ever heard me say a house divided against itself is not going to stand? They're not going to go against themselves. It's because they all benefit from this, so they're not going to divide themselves because they want to. mm, They have to be together in order for them to get more powerful, more money, more funding. So you just need to listen to what Attorney Davis says and the right departments that you need to send a complaint to is DHS. Oh my God. I'm sorry, you guys, I'm in pain. The oh my God, Department of Health and Human Services and Washington and the state legislator. Am I right, Davis?
Mhm.
Yeah.
Yes.
So those three, those are the ones you need to focus on, not so money, not so much that person.
Okay, Harley Neff says, my ex mother in law has my son, and his dad gave up his rights, but now he lives there too. And come to find out, there has been 3 family violence police calls to that house, resulting in his arrest. I'm kind of confused by that. Do you understand that question?
Um,
First of all, maybe I'm assuming Harley's gender incorrectly. But Harley, you asked how come the CPS doesn't catch eyes. They do. They get reports on everything, or they have access to those reports.
what? My ex mother in law has my son, and his dad gave up his rights, but now lives there too. And come to find out that there has been 3 family violence police calls to that house, resulting in his arrest. How come this doesn't catch? CPS knows. I know this is Harley, and I know you're a mom. CPS knows, honey. But the thing about it is that, um, like I said earlier, and several times, is that they favor the abuser all the time. All the time. They're not going to side with you. They're not. They're not going to protect that child. I'm telling you, they're not. So
Okay.
you need to lawyer up. You need an attorney immediately, and you need to lawyer up because you need an attorney that defends your rights, not someone that will say just plead guilty and give you empty promises. And there's nothing worse than an empty promise, right? Especially when it's pertaining to your children. So you need to lawyer up. You need to fight for your kids. Don't give up on them.
Okay. We're coming to the end of the show this evening. Either one of you young ladies want to add anything?
Cassandra, do you want to add anything, honey?
No.
Okay. Well, listen, I want to thank everyone for watching us this evening. And I want to thank my 2 co hosts, Miss G and Miss Cassandra. I appreciate you guys. Today is Friday, which means our next show is Saturday and Sunday. And the shows are at 9 a.m. Both mornings, Saturday and Sunday. So we'll see you guys this weekend at 9 a.m. on Saturday and Sunday. Everyone have a great weekend otherwise. And thank you for watching.